The fate of the Chrysler-Fiat deal is in the hands of the U.S. Supreme Court at this hour. We could be just minutes away from an announcement. Bloomberg's Peter Cook is there with the latest. Peter?
Matt, we've been here all day long waiting for some word from the U.S. Supreme Court whether or not, indeed, they will step in and block Chrysler's sale of its assets to Fiat, the end result of the bankruptcy proceeding that we've been covering so closely here at Bloomberg. We've had a federal bankruptcy judge and a federal appeals court rule that this bankruptcy should move forward, but we've got several groups, including some Indiana pensioners, pension holders, creditors to Chrysler, as well as some consumer groups who have asked the high court to step in, issue a stay, so they could make their case why this should not move forward. In the case of those pension fund holders, they have argued that they were not treated fairly in bankruptcy court. They've also argued that the TARP fund should not be allowed to fund an automaker. They were designed for financial institutions. We've got those consumer groups saying that they have concerns that they will not be able to address safety and liability issues at the new Chrysler if they have a problem with a Chrysler product from the previous entity. So those are some of the issues. We've been waiting all day long. 4 p.m. is the deadline set by the appeals court, Matt, for this transaction to move forward.
We are getting headlines from a lawyer saying that the asset deal is stayed by the U.S. Supreme Court.
All right, let me just check my terminal while we're talking here, Matt, because this is not official from the Supreme Court yet, so that means that they've gotten some indication privately. Again, if the court had not acted, had not issued a stay, then this deal would have moved forward under the terms of what the appeals court said on Friday. So you're seeing headlines here that I cannot see on my terminal in this bright sunlight outside the Supreme Court here.
Well, all we've got so far,
this is not good.
All we've got so far, Peter, you're right, is from a lawyer saying that the Chrysler asset deal stayed by the U.S. Supreme Court. So not anything yet officially from the Supreme Court. Until we hear that, let me just ask you to remind us and remind our viewers what's at issue here, because if I recall correctly, almost all of the secured debt holders had capitulated under the very strong arm of the Obama administration.
Yes, and again, we don't know the grounds for this stay right now, and we also don't know, it doesn't necessarily mean the Supreme Court will agree with those people who requested this stay, simply that this deal cannot move forward at this time, and we assume if there has been a stay granted, that they will have the opportunity then to make their case to the court as to why it should be blocked going forward. But again, the issues at stake here, these secured creditors, as you said, very small percentage of secured creditors were involved here. $42 million is all these Indiana pension funds owned. That was 0.6% of the $6.9 billion in secured Chrysler credit at issue here. So these were small players, but they made their case before the high court. And again, there were other participants, Matt, other groups that asked for the high court to step in here. We should not underestimate the possibility that it was some of these consumer groups who also asked the high court to step in. They were concerned that they would not have the ability, Americans would not have the ability to go after Chrysler in the event of a safety problem uncovered in one of the older generation Chrysler vehicles. They could not go after the new company formed as a result of this partnership. We have, I cannot tell again from these headlines as to what issue it was that may have swayed the court to at least hear this case or to consider this case. But again, we also need to stress that just because the court has issued a stay does not mean this thing is a done deal, although I will say that the Chrysler argument all along has been you grant a stay here and this entire deal is placed in jeopardy. And now the official headlines, as I understand it. Matt, why don't you take those? You can see them more clearly.
We are now getting the official headline. It's only one. The Chrysler asset sale to Fiat will be delayed by the U.S. Supreme Court. So basically, the Supreme Court has agreed to hear this case by the secured creditors. Peter, let me just ask you, first of all, what are you hearing that this means for GM? I mean, obviously, people have been watching the Chrysler case as sort of a model for the GM bankruptcy case to try and get through this quickly, and this is going to certainly slow things down.
Well, this is going to slow things down. Again, we don't know exactly how long. The deadline for Fiat with Chrysler was June 15th. That was the master agreement all along, that this deal needed to be completed by the 15th. This 4 p.m. deadline today was set by the court, by the appeals court. This is important for General Motors because these cases are not identical, but they certainly are very similar. You can be sure that if the Supreme Court decided to hear this argument out, in particular, if they decided to hear the creditors out, that there may be some GM creditors creditors who feel like maybe they should take their chances at the Supreme Court as well. No guarantee of that. These cases are different, but there is a potential for precedent here.
Is this an unusual step for the court to come in here? I mean, after the appeals court has already said forget about it?
Unusual, Matt, but my understanding of the history of this is not out of the realm of possibility. It's happened before. And the closest comparison to this kind of action in somewhat of a strange way are death penalty cases. Those are instances in which justices are asked to intervene with emergency actions. And, Matt, I'm getting someone's going to hand me right here the actual order itself that we're getting from the court. Upon consideration of the application of counsel for the applicants and the responses filed thereto, it is ordered that the orders of the Bankruptcy Court for the Southern District of New York, dated May 31st, June 1st, are stayed pending further order the undersigned of the court. That's Justice Ruth Bader Ginsburg. She handles New York cases. She has signed this order. Not possible for me. I assume that this means she has now, she could have either acted on her own or she could have referred this to the full court for them to consider. I'd have to clarify this, but just from her signature here, it does indicate that perhaps Justice Ginsburg has acted on her own. I'll need to clarify that. She did have the power to do that. So clearly, this is a setback for Chrysler and Fiat. How big a setback remains to be seen. How quickly they'll act on it. You got to remember as well, Matt, that this is a busy time at the court. They're trying to wrap up their work. They issued a whole host of opinions this morning from the bench here. This was not in their agenda. And now, this Chrysler case clearly moving to the top of the agenda, perhaps, for the U.S. Supreme Court.
All right, Peter, don't go anywhere. I've got Greg Miles here on set with me. I want to ask him a little bit about this as well. Greg, you and I have been talking about it for a while now. Every day, apparently, costs Chrysler that they don't sell their assets to Fiat another $100 million. How do you think Fiat is going to react to this?
Well, by the way, remember when you have $100 million a day, that adds up to a monthly rate of $3 billion. Okay, per month. You've got Sergio Marchionne, the CEO of Fiat, trying to wrap up a deal with Chrysler quickly so he can essentially mesh the two operations to stem the bleeding, to try to bring small cars into the United States within the next few years. I think Peter brought up, Peter Cook, our colleague in Washington, brought up a very good point about how quickly will the Supreme Court move to make a decision on this. We don't know whether Ruth Bader Ginsburg, the justice, is going to act on this herself, or whether she's going to float this to the rest of the court. But a key point here, she can say that she wants all the parties involved to file quick briefs, and she may, or the court may want a hearing within just a few days, okay, or they could decide to have a formal hearing process that could drag on for weeks. That would just kill this Chrysler deal, because we know the 15th of June is the final day by which this deal has to be completed with Fiat, or CEO Sergio Marchionne has the option to back out of the deal. Remember, if he did back out, this would be the second major defeat for Marchionne. He tried to buy majority control of Opel, General Motors' European operations, about 25% of General Motors' global sales. Just a few weeks ago, that failed. It looks like Magna International's won out. Now, here we are. You've got the Chrysler deal running into a buzzsaw with the Supreme Court, not to mention with dealers, and also congressmen, both in terms of plant shutdowns and also dealers. So you're talking about a major blow for Chrysler. And also remember, we'll talk about General Motors. General Motors watching this thing very closely, because you and I discussed earlier that although General Motors' unsecured creditors are different from the secured creditors at Chrysler, still both of them are arguing that they were not equitably treated. Or are not going to be equitably treated in the bankruptcy process, and that could float General Motors also up to the process, the court process as well.
I got to say, I've been hearing a lot more, and Peter, correct me if I'm wrong, I've been hearing a lot more about the unfair treatment of the secured debt holders in the Chrysler case, because normally they stand at the front of the line, and here, when the federal government jumps in with DIP financing and then puts them behind or in the same level as union pension funds, health funds. What are you hearing in Washington? I mean, has there been a big scuffle about this the way the administration's handled this bankruptcy?
Well, it's been an issue, Matt. Certainly there have been folks who've raised the argument that the administration stepping in here, in essence, unsettled the playing field for the creditors, unsettled the entire bankruptcy playing field. But the federal government is a player in this, and obviously felt strongly that this was in the public interest. That's one of the arguments that was made by the Solicitor General in asking for the court not to grant this stay today. The federal government filed something that, again, came in this morning morning asking the justices not to take this step, and the justices have taken this step. So clearly there's something at issue here. Again, Matt, it's not clear from the simple order that we've received from the court right now what it is that compelled them to take this step, to consider the stay. There were other factors in play here. We don't know if they have sympathy with that argument, or if there perhaps is another argument that drove them to take this step.
One thing, Peter, as you know, one thing that's been striking, at least on Wall Street, ever since you had Chrysler file for bankruptcy, really has been the whole debate about creditors' rights. Okay, essentially it's property rights. If I'm a senior secured creditor, okay, and then a company files for bankruptcy, I get a right not only to be first in line to be paid fully compensated for what I invested in the company potentially, but also that I'm allowed to be given the time to go through the court process to find out what the value is of those assets so that I'm paid. But this 363 fast-track bankruptcy, what happened is was rammed through so fast is that the secured creditors argue, I didn't really get the time to find out how much the assets of Chrysler were worth. So it's really a battle of speed versus creditors' rights, and that might be what the Supreme Court's interested in.
Although, as we noted earlier, a lot of the secured debt holders did capitulate before the bankruptcy or on the evening of the bankruptcy under strong persuasion. Strong persuasion, let's just say. Peter, thanks very much. Peter Cook standing by there in Washington. Greg here on